Many people believe that the UK GDPR does not apply to individuals, as in individuals don't have to comply with GDPR. In this video, I'm going to explain why that's not necessarily correct. But also, many people misunderstand data protection laws in general and privacy laws in general, believing that no one has any right to privacy or the right to privacy in their information. And again, I'm going to explain why that's not necessarily correct. But first of all, if you're new to my channel, my name is Daniel Shensmith. I'm a barrister practicing in England and Wales. Please do hit that subscribe button if you like my content. And just a heads up, I have a partner for this video called Incogni, which is relevant to the subject of the video, so more about them a little bit later. So in the UK, we have the regime of the Data Protection Act 2018, we have the UK retained version of GDPR, and to the extent that it applies, we also have the Human Rights Act, including the right to privacy and a private family life. More about that perhaps a little bit later. Now, as I said at the outset, many people believe that UK GDPR does not apply to individuals at all. In fact, there's been a heated debate in the comments section, leave your comments below, as to whether or not GDPR applies to individuals. Now, for the vast majority of cases, that's probably true, in that it doesn't apply to individuals. But that is only because there is an exemption within GDPR, known as the householder exemption. So if what you are doing is entirely for your household purposes, then whatever that purpose is will be exempt for the purposes of GDPR, so long as it really is a household purpose. Now, there are several different instances that it may no longer be considered a wholly household purpose. The one that comes up frequently in debates is when you've got CCTV at your home and you encompass part of the external surroundings to the curtilage of your property, and you are continuously surveilling that area either with video or with audio as well. Now, if you capture conversations, let's say of people walking by and they are outside of the bounds of your property, or let's say in a frequent number of cases, that it's your neighbour and the CCTV is trained on your neighbour's property and you capture them either sunbathing or having what would deem to be private conversations, then it doesn't take a stretch of the imagination to realise that the law should step in and intervene in those situations. Indeed, this is the case according to data protection law, with which the ICO firmly agrees, in that the surveillance footage that you capture, if it is outside of the bounds of your property, it needs to comply with data protection legislation. That's not necessarily to say that you absolutely can't do it. It just means that it has to be justified and there is a reason and a valid basis for processing that information, which includes recording it and storing it in the first place. One of those might be consent. You might speak to your neighbour and say, I'm planning to set up this CCTV. It's likely to capture part of your garden. I'm putting it up for security purposes. Are you happy with it? If your neighbour says, yes, that's perfectly fine, so long as you don't XYZ, capture some other part of the garden, the hot tub perhaps, something like that, then they might be perfectly fine with it. Now, this is not to say that you would have to register as a data controller with the ICO for your own home CCTV, but you would have to comply with the data protection legislation because it is no longer a wholly household activity. There was a recent test case of Fairhurst and Woodard, which involved several Ring doorbell cameras, where the defendant in that case was found to be in breach of the data protection legislation and responsible for harassment. Although interestingly, not nuisance, but that perhaps left for another video. I did a whole video on this very case, which I'll link to in the description below. The relevant concluding paragraph was 138, which reads, "For all those reasons, I am satisfied that the claimant's claim that the defendant has breached the provisions of the Data Protection Act and the UK GDPR succeeds. She is entitled to compensation and orders preventing the claimant from continuing to breach her rights in the same or a similar manner in future." And as one of the remedies, in paragraph 139, The court noted that the claimant sought damages for harassment and data protection breaches, and the court found injunctive relief relating to the removal of the shed camera, the removal of the Ring doorbell, and prevention of reinstallation of the driveway camera. So whilst data protection and the UK GDPR predominantly applies to companies, it does, in some situations, apply to individuals. Now, there is another situation regarding to, let's call them auditors. I don't like the term, but let's call them auditors. Citizen journalists is probably a better term. They go out with a camera, they capture lots of people in the name of journalism, artistic creation, whatever you want to call it. They go out with a camera filming and they do capture people on video and they publish that on YouTube. And yes, presumably most of them do make ad revenue monetization from those videos that they publish to YouTube. So to answer this question as to whether or not GDPR applies in those situations, that is a relatively in-depth discussion, which I'm going to come back to just after I talk about my partner for this video called Incogni. In the name of data protection, I've spoken very much before about companies harvesting your data and how often companies will sell on your data and then it could end up in the wrong hands. And so many people think that a company having your data is no big deal because they contact you, they market things to you, you might think that's not such a big deal at all. However, the problem comes when these companies sell on your data and then those companies in turn resell your data and those companies in turn resell your data. And so many companies end up with your data. And by your data, your information, I mean your name, your address, your date of birth, maybe your financial records, maybe all of your browsing habits and all sorts of information. Think of yourself as a jigsaw puzzle that these companies can put together and sell you as a package because other companies will pay big money for your information just so they can market things to you, or if it gets into the very wrong hands, so that they can somehow scam you or take out loans in your name or credit cards in your name. We've had many cases where people have sent money to the wrong people. They've had loans registered against their name, which they didn't take out, but someone has managed to convince the financial organization to authorize those loans in their name because they've got enough information about you. So what is Incogni and why is it important? Well, if I were to task you with finding all of these companies that have your information on a database, you probably wouldn't know where to start. You might think there's 1 or 2 of them or 5 or 10 of them. In fact, there are dozens, if not hundreds of them. And Incogni is a service that you log into with a very simple sign-up procedure, which you'll find linked in the description below with my unique discount. And you will be able to request the removal of all of your data and information from these companies in accordance with your rights under UK GDPR, what we're talking about in this video. Because all of the rights that you have as an individual are contained within the legislation and GDPR. You have the right to be informed when it's being collected. You have the right to have it corrected. You have the right to have it removed. And if these companies hold your data, especially without your consent, and it's been sold on several times, you can insist that these companies remove your data permanently. But if you were to do that yourself, it would take you a very long time. Whereas with Incogni, you sign up, you put your details in there, they will contact all of these companies for you, and then they will provide you a rolling progress report week after week showing you the updates as these companies remove all of your data from their systems, and essentially you end up disappearing from their databases. It is a service that I personally use. It is linked in the description below for my unique discount. Go and check that out if you value your privacy. So now back to the situation as to whether or not GDPR applies to, let's call them citizen journalists and the like. Well, as I was talking about the holy household exemption before, if somebody goes out and it's a hobby and they just film and it is purely for their own purposes, then it would probably still be a holy household exempt activity. However, the grey area and the question comes up whereby they are making money from those videos that they produce. That is quite feasibly then not a holy household activity. However, Does the GDPR apply, and is there any way around it? And frankly, how do they get away with it? Well, there are several different exemptions to many of the GDPR aspects, and they include, as you might imagine, journalism, academia, literature, research statistics, archiving in the public interest, and various other things. Now, in short, let's take the journalism and/or artistic purpose as an exemption for the purposes of this video. Now, if one of those exemptions applies, then they would relieve you as the person with the video camera from all of the obligations under the UK GDPR, except for the following. It would not exempt you from the security and accountability principles of holding that data. It wouldn't exempt you from having a lawful basis. And it wouldn't exempt you from the conditions of processing special categories of personal data, which would, for example, be those of a very personal nature, just to name a few. However, in one of these cases, the exemption would apply to the extent that the data controller, the person with the video camera recording the footage, is processing the personal data and reasonably believes that complying with those provisions would be incompatible with a special purpose, which includes journalism and academia and so on. But it must be more than just an inconvenience. So it's got to be that complying with all of the GDPR provisions would be incompatible with that journalistic or that artistic creation. Secondly, that the processing is being carried out with a view to publication of some of that journalistic or artistic or even academic or literary material, and that they reasonably believe that the publication of the material would be in the public interest, taking into account the special importance of the general public interest in the freedom of expression, and any specific public interest in the particular subject and the potential harm of individuals. So what does that really mean? Well, anybody with the video camera who is filming out in public and captures somebody's personal information, obviously that person can uphold their journalistic and artistic exemption to the extent that it is reasonably necessary for the publication to be in the public interest to maintain the freedom of expression, but weighed against the particular information of that data subject. A data subject being anybody who is personally identifiable, which would include the potential of being identified by filming their face. Many people have said before that that doesn't apply, but it very much does apply. In fact, the courts have taken a very specific approach to photographs, so by extension, it would also apply to video. For example, the court has allowed the written publication of certain events, but the court has restricted the publication of photographs of the same event, essentially saying that somebody who can see the photographs would be acting as a spectator in situations that they really ought not to be a spectator, whereas the written reporting of those events was deemed to be okay. Now, if this were a broadcaster, obviously there are broadcast guidelines such as the BBC that have to comply with their own guidelines and the Ofcom broadcasting code. But as for individual citizen creators, journalists, or video artists, they will likely have to comply with UK GDPR if they are generating revenue from their videos, but will probably, in most cases, be able to rely on a journalistic or artistic exemption which relieves them of most, not all, of the provisions of UK GDPR. And for the most part, common sense will prevail in that if data is really sensitive, then it ought not to be published. But let's say, for example, a vehicle number plate is not extremely sensitive, and it would be, in my view, in the public interest and the interest of the freedom of expression if you film somebody, let's say, committing a road traffic offence, and you've captured their vehicle number registration on there, and you are reporting it as a citizen journalist, or it's for artistic or creative reasons, and you've ticked those boxes, and the guidance for the ICO I'll link in the description below, then you are probably perfectly fine, because you'll probably have this exemption against most of the UK GDPR provisions. However, it gets even more complicated than that, and it reaches back to my reason for partnering with Incogni for this video to erase your personal data from companies that really should not have it. Again, the link to that is in the description below. But the reason I mention that again is for the importance of personal information. Now, individuals can be responsible for the tort, the civil wrong, of the misuse of personal information, which can also amount to harassment if it happens on more than one occasion, because harassment is a statutory tort under the Protection from Harassment Act, whereas the misuse of personal information is a common law tort. In other words, it came about through case law decisions. Now, broadly speaking, there is a two-part test for the misuse of private or personal information. Stage one is, was there a reasonable expectation of privacy in the information? This will assess whether a prospective claimant has a reasonable expectation of privacy in that relevant information which has been used, shared, or distributed or disseminated in some other way. If so, such as medical or financial information, which is inherently personal, then a court would move on to the second test, which is a balancing exercise. If there is a right to a reasonable expectation of privacy in that information, the court would assess whether that expectation of privacy outweighs any prospective defendant's right to the freedom of expression or any other competing right, insofar as they might apply. So this balancing exercise between the expectation of privacy and the right to publish information, on the other hand, is weighed up to determine whether or not an individual, or indeed a company, is liable for the tort of the misuse of private information. Now again, this predominantly applies to companies, most frequently newspapers, because they are the ones publishing information out of which they generate interest and readership, and there is always a risk that when they publish something, it falls on the wrong side of that, i.e. that an individual about whom they publish information had a reasonable expectation of privacy in the information, and that expectation outweighs the freedom of expression of printing the information, then in that situation, the newspaper might be liable. Case in point, the whole Prince Harry and the phone hacking case against the newspapers. One of the limbs on this case was the misuse of private information. But where most people trip up is that this doesn't just apply to companies, it can apply to individuals as well. So if one individual were to somehow garner information about another and then spread it online, then that individual could be liable personally for the tort of the misuse of private information. If they've done that more than once, it could amount to harassment. Then that person might end up being prosecuted for the criminal offence of harassment, which arises out of the same set of facts of the misuse of that private information. So as you can see from this overview video, which it really is an overview, we could spend 2 or 3 days talking about GDPR and data protection and how it applies. I've barely scratched the surface of how this applies in different situations. You can see how this is not necessarily as clear-cut as many people seem to think. But if you do value your personal information, don't forget to check out Incogni, linked in the description below. This will help you to erase your information online. Please do remember to hit that like button if you find my videos useful, and make sure you subscribe to the channel and hit the notification bell for further updates. And as always, thank you for watching.